Yes, ma'am.
All right, so let me just tell you something. When you
Okay,
are
sure.
ordered, when you are ordered to be in court, you're supposed to be in court. There will be none of this, oh, I refuse to come, because if you
Oh.
refuse to come, what's going to end up happening is the deputies are going to bring you anyway.
The court is going to sentence you to the 10 years in the prison. There's a $1,000 fine. That is the sound of a door locking. Not a physical door made of steel and bars, but a transactional door. A door that swings shut the very second a human being decides that a courtroom summons is a suggestion, not a command. We are looking at a cascade of failure that begins with a single, seemingly small act of defiance. Refusing to stand up, walk 30 feet across a jail corridor, and face the music. Think of a detention center transport corridor at 8:47 a.m. A deputy holds a clipboard with a transfer list. A name is highlighted in yellow. Next to the name, the box marked refused is checked. That tiny check mark made with a standard issue county pen isn't just an administrative note. It is the ignition key for a machine that grinds slowly but absolutely, and it turns a standard felony court docket into a demolition derby. That check mark is where we start. Before we go deeper into what the documents actually show, make sure you're subscribed to Crime Files 911, because we don't just cover the story, we follow the evidence. The machinery of justice in this courtroom operates on a frictionless, terrifying logic. The judge lays out the physics of the situation with the clarity of a ballistics expert. When you are ordered to be in court, you are supposed to be in court. There will be none of this, oh, I refuse to come. Because if you refuse to come, what's going to end up happening is the deputies are going to bring you anyway. The state possesses a monopoly on force. That is not a political statement, it is a structural reality. A defendant who believes they can veto their own transport has fundamentally miscalculated the power gradient. The judge forces the defendant to visualize the end of the argument. You are going to lose that argument when you get into a physical confrontation with a detention deputy. It is a promise of physics, not a threat of punishment.
Yes, ma'am.
All right, so let me just tell you something. When you
Okay,
are
sure.
when you are ordered to be in court, you're supposed to be in court. There will be none of this, oh, I refuse to come, because if you
Oh.
refuse to come, what's going to end up happening is the deputies are going to bring you anyway. And who do you think is going to end that argument when I tell the deputies to bring you? You're going to lose that argument. So this whole childish thing where people are not coming because you have something better to do, or you just refuse to come, you will be brought over, and you're going to lose that argument when you get into an argument with the deputy about whether you're coming to court or not. Do you understand?
I understand, Your Honor. I thought it was June 29th.
Here's the thing.
That's it.
This is why people are at the Bexar County Jail in custody, because you have someone in authority telling you
Oh,
that
okay.
you're scheduled to go to court today, and your thing is, no, I'm not coming. So I'm telling you, the next time a deputy tells you that you have court, you better come. Do you understand?
The refusal is not a display of strength. It is a demonstration of catastrophic risk assessment, and the court catalogs it immediately as evidence of a person who cannot regulate their response to authority. This brings us to the exploitation case. The surface charge is a third-degree felony, but the evidence inventory turns it into a moral X-ray. The court reads the PSI report, the pre-sentence investigation, which transforms a legal document into a transaction history of betrayal. We are not looking at a single fraudulent purchase. We are looking at a granular line-by-line audit of a life lived entirely on someone else's diminishing credit. The judge scrolls through the items, and the rhythm of the list is its own condemnation.
So, Miss Essex, I want you to know I listened to the testimony that was given by your father, but I've read the PSI report. Are you still, and I don't know if you want to call your client as a witness, she's given up the right to remain silent, but in the PSI, she's saying that she was given the credit card. But in looking through things, she wasn't given the credit card. And what she's spending the credit card on, I mean, there are many things with Dobie Nails, going to the dermatologist, going to HEB, going to 7-Eleven, Best Buy, Shell Station, the Alamo Cafe, Best Western Hotel, SQZ, Trip Reggie, Specs Liquor, Crown Cap, and there are Dobie's Nails, 7/22/24, another Dobie's Nails, 7/22/24, all in the same day. Then there's Walmart, then there's Five Below, then there's Specs Liquor, then there's Ross, then there's Sushi Place, then there's FedEx, then there's American Best, Dollar Tree, Burlington, Wine and More, Chili's. So she, KFC, Torchy's, Don and Ben's Liquor. So is she still insisting? Oh, Saltgrass, is she still in?
Which ones?
A dermatologist visit, HEB 7-Eleven, Best Buy, a Shell station, the Alamo Cafe of Best Western Hotels, QZ, Trip Reggie, Specs Liquor, Crown Cap, and then the item that lands with a sickening thud. Dobie Nails 7-224 and another Dobie nail charge identical on the same day. There is no economic anxiety here. There is no desperate purchase of bread or medicine. This is a consumerist rampage on a retiree's dime. The irony explosion occurs when the defendant tries to introduce the defense of familial permission. The victim is her mother. The mother is in a retirement facility under a legal guardianship so strict that a third party controls her finances because she is legally deemed unable to care for herself. The defendant went into that vulnerable space under the guise of caregiving. I want to be with my mom. I want to help my mom, and walked out with the plastic keys to a financial spree. The judge asks a question that functions as a guillotine. Did she expect her mother, who's in a retirement home, to pay this back? The silence that follows is filled by a list of establishments that do not offer credit: FedEx, Dollar Tree, Burlington, Wine and More, Chili's, KFC, Torchy's, Don and Ben Liquor, Saltgrass. It's a geography of consumption that maps perfectly onto the defendant's appetites and has zero coordinates for the mother's well-being. The paperwork already knew. The defendant, now under oath, attempts the pivot of promised restitution. I would pay it back. The judge strikes the nerve center of that lie with a fact. No, you say you would pay it back now, but that's because you have a criminal case. This is the difference between remorse and legal exposure. The only credit card debt the defendant is interested in settling is the debt to society, and only because the interest is measured in decades.
How many times have you been on probation?
I've been on parole.
Did they put you on probation in Travis County?
No, I did the county time and then I went to the prison for 29 days.
I'm gonna show you this, and it says that in August 2015, you're put on probation for 5 years.
Oh, okay.
And then
That's a PSI, right?
Well, that was probation, and
right.
then just under 4 years later, you were revoked, sentenced to THC. Were you not on probation in
Okay,
Travis
I thought
County?
it's PSI. Is that different or no?
PSI is something that happens post
Or before it
finding
gets
of guilt,
sentenced, right?
re-sentencing.
Yeah.
Yes. This looks like you're on supervision in Austin.
Okay,
The 3.5, almost 4 years. Is that fair?
yes, that is correct.
What happened?
I would have told you, it was a long time ago. I guess I was on pre-sentence trial, whatever it was, and then I ended up going to prison in 2014.
The court absorbs the father's testimony, a man asking for mental health and substance abuse treatment instead of incarceration.
Yes.
Mr. Essex, how are you related to Kimberly?
She is my daughter.
Is your daughter? So you're familiar with her legal situations?
Correct.
Okay. You're aware of what she's charged with today,
Correct.
and you're aware that she is facing up to 10 years in prison.
Yeah.
Do you feel 10 years is going to help her?
As a father, 10 years, gee, but I don't see at her age what benefit that would be. And as you explained to me earlier, maybe a different scenario would be the mental and alcohol treatment center,
Right.
which sounds really more applicable to this case. I think Kimberly has obviously issues with alcohol and drugs, but also the mental issues have not really been addressed. She feels that she has drugs implanted in her stomach and her brain, just various things that I think she would benefit from the other program in the prison.
All right. Is there anything else you would like to tell the judge?
She's a good person. She just laid hard.
It is a reasonable plea from a reasonable man, but the court has the audit trail. The court has the guardianship. The court has the same day double charge at a nail salon while a retired, incapacitated woman sits in a care facility. The judge denies probation, finds the enhancements true, and sentences to 10 years in the institutional division.
All right, so Ms. Essex, I want you to know that I heard everything that has been said. I've internalized everything. And this is what I want you to internalize, right? You've got to realize that the person that you committed this offense against was your mom. Your mom is in a retirement facility. Your mom is in such a state that she has a guardian, which legally means she's not able to take care of herself. And what you did, under the guise of, I want to be with my mom, I want to help my mom,
Yeah.
you went into her retirement home, her apartment or community. And what you did was you took credit cards from a vulnerable person and you had no qualms about using those cards. And you would still be using those cards probably today, but not for the fact that the guardian of your mother said, hey, somebody's been using these credit cards. You had no intention for paying for that.
No, I would pay it back.
No, you say you would pay it back now, but that's because you have a criminal case. I don't think that you are a good candidate for probation. I'm not going to give you probation. I'm going to find you guilty. The enhancements are going to be true. The court is going to sentence you to the 10 years in the prison. Your credit for any time served. There's a $1,000 fine. There's to be no contact with Dorothy Essex, Philip Essex. There's to be restitution, if any, to Dorothy Essex. I'll request a therapeutic community. There's to be no residing with any vulnerable person or anyone who's younger than 17 years of age or older than 65 years of age. The court, as previously stated, is giving you credit for any time served. Did you review the document entitled Trial Court Certification? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And yes.
The $1,000 fine is almost an afterthought, a decimal point on a catastrophe. The narrative pivots to a parallel structure of consequence. The next docket entry introduces a defendant whose decision-making process is indistinguishable from the first. The charge is unauthorized use of a motor vehicle and possession of a controlled substance, specifically methamphetamine. But the aggravating element, the detail that elevates this from a property crime to a public safety emergency, is the presence of a 3-year-old child in the backseat. Think of the interior of a stolen vehicle pulled over on a Texas highway at night. The dumb light is on. In a diaper bag amidst the crushed Cheerios and a sippy cup, a crystalline substance that stinks to high heaven. As the judge notes, off gases its toxins into the sealed environment. This isn't a hypothetical. The judge references a previous incident where meth brought into the physical courtroom itself took forever to air out. Now, imagine that chemical saturation in the developing lungs and brain of a toddler. The defendant's defense is layered with fatal passivity. She claims she didn't know the car was stolen. She claims the drugs in her purse were incidental. She claims she signed over temporary parental rights to her own mother. The judge dismembers this defense with a single, linear question. How long had you known her? The answer is 8 years.
Fend for themselves. That 3-year-old is 100% dependent upon you. And what did you do? You drove in a vehicle that was stolen with this Perales person. And then not only that, you all are doing drugs in the car. There's drugs in the car. And let me just tell you, meth stinks to high heaven. We had a case in this courtroom where someone brought in meth, and it took us forever to get that sent out of the courtroom. And you driving around with a 3-year-old, impacting their brain cells with meth and marijuana in the car.
In my defense, she didn't let me know that the car was stolen.
Here's the thing, there's no defense. There's no defense to driving around in a vehicle. And let's say you didn't know it was stolen. You had meth in your bag. She's driving away with drugs. You can't tell me that you don't know the people you hang around with. How long had you known her?
I don't know, for 8 years.
All right, so you've known her for 8 years. So number one, you know what type of person she is. You've known her for 8 years. And if you were to tell me it was a complete stranger, then I would be asking you, why are you getting in a vehicle with a complete stranger when you have a 3-year-old? If you want to put your life at risk, then go for it. But you're putting that child's life at risk by doing that. And signing over your rights to your mom, I already know that's the easy way out. And what ends up happening, people are in CPS court, and you know what they do? They sign their rights over to a relative. CPS gets out of their life, and then guess what they do? They go back to that relative, and then they have that child again. Not in this court. Good luck to you.
The moral logic is irrefutable. You've known her for 8 years. So, number one, you know what type of person she is. If she were a complete stranger, the court would demand to know why a mother would get into a car with a stranger while holding a 3-year-old. The defendant has tried to operate in a gray area of plausible deniability, but the law paints in black and white. You either knowingly endangered your child by association with a criminal enterprise, or you recklessly endangered your child by getting into a car with an unknown drug user. There is no third door. The judge spots the CPS loophole instantly. The act of signing over rights to a relative is a legal hack to get the state out of your life, and then you go back to that relative and you have that child again. The court erects a barrier: no residing with minors, no contact, a 4-year deferred adjudication with 100 hours of community service, and a demand for a GED. The system is using a scalpel to sever the cycle. The paperwork already knew. The courtroom doors open again on a violation of community supervision.
Good luck to you.
On or about the 9th day of February 2024, in Bexar County, Texas, the defendant, Mariah Lopez, committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
Not true.
Violated condition number 2, on or about the 19th day of January 2024, in Bexar County, Texas, the defendant, Mariah Lopez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 14G, on or about the 19th day of January 2024 in Bexar County, Texas. The defendant, Mariah Lopez, did then and there fail to register, attend a state accredited battering, intervention, and prevention program with approved agency in violation of condition number 14G.
How do you plead to that? True or not true?
Not true.
This is the post-credits scene of the criminal justice system, where the abstract leniency of probation collides with the concrete reality of human impulsivity. A defendant walks into the booking area of the jail. She is in a line of inmates, waiting to be transferred to the main facility. She steps out of that line. This is not a reaction to an immediate threat. According to the testimony of the Bexar County Sheriff's deputy, the defendant walked away from the line and went straight to the victim and started striking her. The overhead camera captures it. The booking sergeant reviews the footage, signs, and dates it. It is an unprovoked, premeditated assault executed inside a panopticon of surveillance.
And so aside from providing the video to the investigations part of BCSO, did you have other interaction with this case?
I interviewed both and I'm in charge of booking, so I'm aware of the inmates that are in our section.
Okay, and so do you recognize the defendant?
Yes, I do.
And how do you recognize her?
She was one of the inmates in booking that day.
Okay, and was she involved in an altercation?
Yes, she was.
And what happened?
She was in line to be transferred to the main jail. She walked away from the line and just went straight to Latrell and started striking her.
Okay, and do you remember the defendant's name? Would it help?
Latrell.
I'm sorry, would it help if you had to report to?
Oh, okay. Latrell Rebecca.
And that's the victim or the defendant?
Oh, the defendant.
I'm sorry, it's a little confusing. Is that the victim in this case?
I'm gonna object to her memory being refreshed while she's
Oh.
holding the document.
All right.
Your Honor.
Could you read? And if there's no objection, I believe this is the question.
Judge, my objection is to her memory being refreshed and her reading. From her
All right, if that's a report, you can review it to refresh your memory.
Yeah, just
So state, what is the question?
who was struck in that video?
Latrell Rebecca.
And who struck?
Oh, who was striking? Oh, Lopez, Mariah Lopez, I'm sorry.
And what was the date that this happened on?
February 10th, 2024.
Okay, and where did this happen?
South Tower booking.
Okay, and is that in Bexar County, Texas?
Yes, sir.
I pass the witness, Your Honor.
Any questions?
Sergeant, you were present that day at the jail
Yes, sir.
and you have personal knowledge that Miss Lopez assaulted the allegedly assaulted that other inmate?
Yes, sir.
And so you don't know that if the other inmate maybe had said something to Miss Lopez to get her, to kind of aggravate her?
She wasn't near her.
So you don't know what their interactions were beforehand, do you?
I do.
No further questions, Judge.
All right,
No further questions.
Is this witness excused or subject for recall?
The defendant rejected a plea offer that her own attorney described as reasonable, a plea that would have disposed of multiple cases. She insisted on a contested hearing. The state calls the deputy. The video is admitted. The defense attempts to float the idea that the victim might have said something, might have provoked her. The deputy eliminates that possibility with 2 words: she wasn't near her. The attack was a predator's initiative, not a praise response. The motion to revoke is granted. The 5-year sentence is imposed.
All right, this is what the court is going to do. The court is going to grant the motion. Court will sentence you to 5 years in the prison. There's an affirmative finding of family violence, credit for any time served, and there's to be no contact with the complainant in this case. And then, all right, I'm showing you what's in the court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? All right, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. Do you understand? All right, because this is a felony conviction and because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition.
This brings us to the final exhibit in this docket of self. Destruction, a defendant who does not want to dress for trial. The visual anchor is the color red. In the taxonomy of the Bexar County Jail, colors are a status code. Blue for general population females, orange for general population males, tan or gray for trustees, yellow for pregnant inmates. Red is reserved for administrative segregation, high risk, or gang-affiliated inmates. A defendant stands before the court in a red jumpsuit, claiming he was unaware of his own jury trial date. The judge dismantles the claim with a procedural fact. A deputy at the jail tells you you're supposed to be dressed for trial. The clothing is a signal. Rejecting the street clothes is a performative act of non-compliance. The judge offers a guarantee that is chilling in its simplicity. If you refuse to change, you're going to be going to trial in that red jumpsuit. And you know why? Because it's going to have been your choice. The jury will see the uniform of the segregated unit before they hear the presumption of innocence.
And you know why you're going to be going to trial in that red jumpsuit? Because it's going to have been your choice. I am not having you come back to this court again where you're pretending as though nobody told you you had a jury trial. The other thing, you're saying that your attorney is telling me that you want another attorney?
That's correct.
All right, then you need to hire one. Do you understand?
I don't have any support issues. Support at all as we speak right now at the moment.
What
And
support for what?
It's ordinary to hire an attorney.
Oh, well, then this is your attorney. This is what I've discovered, and I've told many people this before. This is what ends up happening. When you, as a defense attorney, are placed to represent somebody and you've been appointed to represent them, number one, there are certain qualifications that you must have. This is a 3rd-degree felony. It may be bumped up to a 2nd-degree felony based upon what's in the indictment. This attorney would not have been appointed to your case if he didn't have the qualifications to be on this case. I don't allow attorney shopping in this court. Whoever comes up on the wheel, that's who your attorney is. The state will tender an offer to your attorney because I require the state to tender an offer. State can make an offer and say, we're offering 20 years. The state can say they're offering the maximum. Guess what? Your attorney has absolutely really no control over what the state is offering.
So what's
Even if your attorney were to go to the state and say, well, these are the weaknesses in your case, and this is what my client is willing to accept, the state can still say, I am not going to offer your client what he wants. The only thing I will offer you is A, B, or C. And your attorney ethically is obligated to tender that offer to you. Now, you can accept it or not. That's completely up to you. There are certain rights you have when you're charged with the offense. One of them is whether or not you will accept an offer or not, and whether or not you will testify at trial, and what plea you will enter. Do you understand? So you're not getting another attorney. If you want to hire one, you are more than welcome to hire one. So this is your attorney. Next question.
Why does my case carry at least prison time and not probation?
Here's the
or
thing.
anything?
You will have to speak to your attorney. What I can tell you is There are certain cases, number one, that you're not eligible for probation. There are certain cases that if you go to a jury trial and if you are found guilty, you're not eligible for probation. There are some cases that if you go to jury trial, maybe you're eligible for probation from a court. But I cannot tell you whether or not, just based upon looking at your case, that which would be the indictment for me, whether you're eligible or not. What I can tell you though, usually if you have a repeater count and you go to a jury trial, you're not eligible for probation. So you need to speak to your attorney about that. And I'm sure your attorney will tell you whether or not you're eligible. Think of criminal history this way. If you have somebody that you loan money to, right? Let's say somebody comes to you and they say, can you loan me $50 and I'll pay you back next week? And you say, yes, I will loan you the $50. What are you going to use it for? Oh, I got to pay my electric bill, which that would be a good electric bill these days. And that person gets the $50 and they don't pay you back. And you just, you said you pay me back on this day, you're not paying me back. That person comes to you for a second time and said, look, I'm in dire straits. They're about to cut off my electric bill. I need $60. And you tell them, you know what? I gave you $50 just last week and you never paid it back. And they're like, I know, I'm so sorry for doing that, but I promise you this time I will pay it back and I really need the $60. So you loan them $60 and they don't pay it back. And then they come to you for a third time. You may say, I'm not going to loan you any money. I don't care what your problems is because I've loaned it to you 2 times before and you haven't paid it back. Sometimes people view criminal history that way. And when I was a prosecutor, sometimes people would view criminal history that way. They would say, you know what? I gave you probation before, you didn't do well on it, and you pick up another case. I gave you probation the second time, you didn't do well on it, and you pick up another case. So maybe that could be a reason why people make offers that they make. But what I want you to take away from this conversation is this attorney, according to the will, is qualified to handle the type of case that you're charged with. And I would tell you one of the qualifications they must have, and Mr. Gomez, correct me if I'm wrong, he has to have tried cases before, and he has to have tried felony cases before. You can't just have tried misdemeanor cases and then come to felony court and say, oh, I'm qualified. That's not how it works. So he's tried the necessary cases. And if you are upset by the offer that he is tendering to you, no, that is the offer that is the state has made. And in this court, I require everybody to treat each other with kindness. So I guarantee you, when the state made him that offer, the state wasn't mean. The state just says, this is the offer I'm making. And I expect you to treat your attorney with respect. I'm sure your attorney will treat you with respect. But again, if you want a different attorney, you need to retain an attorney. So that means you need to go out and hire an attorney. And if you don't have the money to hire an attorney, then this is your attorney. Do you understand? The other thing I want you, that's either yes or no.
Yes, miss.
The other thing I need you to understand, and again, we're not doing this anymore. If you are at the jail and they're ordering you dressed for court, that's me ordering you dressed for court because you're up for trial. And I will not have any qualms whatsoever with you going to trial dressed in that red uniform. And you and I both know that red uniform has several meanings attached to it, just the way the orange ones does and the blue ones does. The blue one for females, orange, just regular inmates. The red, gang member, age issue, in admin segregation. Yellow with stripes, pregnant, or just yellow, pregnant. Tan or grayish looking color, trustees. So if you want to come to trial dressed in red, that is completely up to you. Do you understand?
Yes, miss.
Do we understand each other?
Yes, miss.
Do you understand the offer that the state has made to you? That's either yes or no.
Yes.
Do you need to confer with your counsel anymore on the offer that the state has made to you? And if you would like to make a counter offer, I'm sure if you would tell your attorney, well, I want to accept this, but this is what I will accept. That's what's called a counter offer. But what that means is you're telling the state, I'm not accepting your offer. I will only accept this. So that means that you're rejecting the state's offer and it may or may not appear for you again. Do you understand?
Yes, miss.
And I'm sure this attorney will be able to tell you what your range of punishment is in this type of case. I cannot tell you that because I don't know the facts of your case. The only thing I have before me is an indictment. You understand?
Yes, miss.
Do you need to speak with your attorney some more? Do you need to see what evidence the state is saying they have?
No, miss.
Have you already seen that?
Not quite yet, but yes, I have.
Mr. Gomez, will you let him see that since we're all here?
I could confer with him again.
All right, so your attorney is going to confer with you and the state will let him see their file so you can see their file and see what they have, okay? All right, thank you.
The defendant also demands a new attorney, claiming dissatisfaction. The court explains the wheel system. You do not get to shop for a public defender like you are browsing a menu. The attorney on the case is qualified to handle the specific degree of felony. The offer from the state is not the attorney's fault. It is a cold calculation based on the defendant's criminal history. The judge delivers a parable that functions as the Rosetta Stone for understanding prosecutorial discretion. It is the loan analogy. You lend a man $50 for his electric bill. He doesn't pay it back. He returns a week later, desperate, begging for $60 for the same bill. You loan it against your better judgment. He defaults again. The third time he comes to you, the well of trust is dry. That is how the state views the recidivist offender. They gave you probation the first time. You violated. They gave you a second chance. You violated again. The offer on the table is not a reflection of your attorney's skill. It's a reflection of your own transaction history of broken promises. The defendant is facing a habitual enhancement that carries a minimum of 25 years.
All right, so this is your attorney. This is what I know. We can go off the record. Here's the thing. An attorney will tell you, this is what the state is offering you. You can either accept it or reject it. This is a case that the state has made the decision to waive the habitual. If we were proceeding on the habitual, you know what your minimum is?
Right.
What?
25.
And so you're saying you're not satisfied with your attorney when the state is not proceeding on the habitual.
I'm like, no, I'm like,
What does that mean?
all right.
His attorney, the one he wants to fire, has successfully navigated the state into waiving that habitual paragraph, taking a life-destroying minimum off the board. The defendant stands there fuming about representation, oblivious to the fact that his lawyer just saved him 2.5 decades of his life. The plea for 10 years is entered.
Saldana, could I have parties announced for the record for the state
Marjorie Hillman for the state.
defense?
Your Honor, good afternoon. Frankie Sandoval on behalf of Mr. Saldana.
Are you Mr. Saldana? Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Saldana, did you review the document entitled True Bill of Indictment with your attorney, and did you understand it?
No.
All right, you need to speak up.
No.
All right, counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are waiving the habitual, the enhancement paragraph, and we're proceeding on the underlying offense.
Any objection?
No objection, Your Honor.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Ma'am,
Did you understand you're charged with injury to a child, bodily injury intentionally or knowingly? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
yes, ma'am.
All right, you're moving very slow with your answers. Do I need to speak up for you?
I think everybody can hear me pretty clearly. Yes, ma'am.
All right. I'm sorry, what?
Yes, ma'am.
Are you understanding everything?
Yes, ma'am.
All right. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Saldana, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you satisfied with the way you've been represented?
No, ma'am.
All right, do you want to go to a jury trial?
If I'm not satisfied with the way I'm being represented, no, ma'am, I don't want to go to trial.
All right. All right, so this is your attorney. This is what I know. We can go off the record. Here's the thing. An attorney will tell you, this is what the state is offering you. You can either accept it or reject it. This is a case that the state has made the decision to waive the habitual. If we were proceeding of the habitual, you know what your minimum is?
Ma'am,
What?
25.
And so you're saying you're not satisfied with your attorney when the state is not proceeding on the habitual.
I'm live. Yes, ma'am, I'm live.
What does that mean?
All right.
All right, we're back on the record. Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. There are no applications. The state is taking in consideration County Court Cause number 722472, 2024 CR 3082. There's an affirmative finding of family violence and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
No.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contents.
State, any evidence?
Your Honor, the state offers state's exhibit number 1 and all attachments.
Any objection?
No objection, Your Honor.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence exhibits 1 and attachments. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
In the interest of justice, that would be our request, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Saldana presents himself before you, accepting responsibility for the matter before you. As the court may be aware in reviewing his record.
Excuse me, just 1 second. Mr. Cox, if y'all can move down to the other end, we're on the record. That's okay. All right, we're back on the record. Yes.
Thank you, Your Honor. As the court is aware, Mr. Saldana is currently on parole on a previous case. He would respectfully request, and I make this request on his behalf, that although we understand and he understands not binding, we would ask that the sentence that will be imposed today by this honorable court run concurrently with whatever actions parole takes on his former case.
Court is going to do, as previously stated, the court is finding you guilty. The court will sentence you to 10 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. This will run concurrent with 2014 CR 10282B. Take in consideration County Court Cause number 722472, 2024 CR 3082. There's an affirmative finding of family violence. There's to be no contact with Mallory, Malerie Saldana, Jaden Saldana, Jayden, and Irene Portelis.
The judge, ensuring the record is airtight for any potential appeal, walks him through the rights he is waiving. The punishment is prison. The family violence finding is affirmed. The prohibition on firearms is absolute.
Your minimum is 25 years in the prison. You understand? Your attorney was able to get you less than the 25 years. Do you understand? And I don't know what you don't understand. It appears that prison is not teaching you what it should be teaching you. But if you come back out and you commit another offense or alleged to have committed another offense, potentially based upon whatever offense that may be, you're looking at a minimum of 25 years. Do you understand?
So we return to the empty chair, the one where the defendant refused to walk over from the jail. What connects these fragments of docket sound? It is a shared delusion of sovereignty. A belief that you can refuse a court order, spend stolen credit on sushi and wine, drag a toddler through a meth cloud, punch an inmate in the booking line, or refuse to take off a red jumpsuit, and that the system will blink. Judge Boyd's courtroom operates on a clock where the minutes are marked by the loss of leverage. Every act of refusal is a brick removed from the foundation of judicial mercy. You do not win the argument with the deputy. You do not out-logic the PSI report. The criminal justice system is a Leviathan that moves slowly, but it moves on rails. You can either walk into the courtroom and participate in your own defense, or you can be dragged in, physically and then legally, until the sentence is read and the $1,000 fine is assessed and the door slides shut. The paperwork already knew, because the paperwork doesn't care about your feelings. It only records your choices. This is the record of Bexar County. If you want to read the raw data of human fallibility, the court dockets are public. I want you to look up the docket for case number 25 PF 25148, or any of the judgments referenced in the deferred adjudication hearings. Read the conditions of community supervision. Read the stipulations of evidence. And then ask yourself the question this channel exists to explore. At what exact point in these paper trails does the presumption of rehabilitation vanish, replaced entirely by the administrative certainty of a cell? Answer that in the comments below. If this forensic breakdown of the judicial machine gave you a new perspective on how leverage is won and lost inside a courtroom, make sure you like this video, share it with someone who thinks the system can be scammed. Subscribe to Crime Files 911 and turn on notifications. We follow the evidence, not the narrative.